2, 1.
Oh yay, oh yay, oh yay. This Honorable Supreme Court of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Thank you, Mr. Hebner. Good morning to counsel here with us on Zoom this morning.
Good morning.
We also welcome those of you who are watching our proceedings here today by live streaming on YouTube. This is the October 2021 docket of the Tennessee Supreme Court. We have 2 cases we're doing by Zoom this morning and 2 on brief. We appreciate the participation of the lawyers. We hope that those of you who are watching online will use this as an opportunity to learn about the Supreme Court and our justice system in our state as a whole. In a moment, we're going to begin with the first case on the docket. When we do so, each side will have 30 minutes to argue. If the appellant wishes to reserve any time for rebuttal, please do so at the beginning of your argument. I do want to note just a moment that before we start court, this is the first time we have had court without Justice Clark. The 4 of us will do our best to carry on the work of this court. This is what she would have wanted, but she has left a lasting legacy. Her influence on our judicial system and access to justice will endure for generations. We are a family and we will miss her very much. Mr. Hebner, you may call the first case.
State of Tennessee versus William Eugene Moon.
May it please the court, I'm Drew Justice from Rutherford County, Tennessee for the appellant William Moon, and I will reserve 6 minutes. The right standard, the best standard for reviewing speedy trial claims is de novo review. De novo review is consistent with this court's prior holdings, which state that for all mixed questions of law, review is conducted de novo with deference shown only to the trial court's factual findings. Ironically, on my other issue in my appeal, the harmfulness of the evidentiary error, this court has expressly ruled in Harris versus State that type of error, even though it's very factually intensive, it's nuanced, that type of error is a mixed question that's reviewed de novo. And yet, here we are having to debate this, what type of review for a Sixth Amendment issue on something as important and as universal as a constitutional right. The state wants to say that we should show deference to a lower court. Now, what is abuse of discretion boiled down? It's basically deference to a lower court's mistakes. It's telling a trial judge, you know, we think you got it wrong here, but we're not really sure, and so we're going to let it slide.
You know, Mr. Justice, this is Justice Bivens. We have an abuse of discretion standard that applies in many instances, and it doesn't necessarily mean that they've made a mistake. Don't you think that's a little bit much to go that far?
It's what I'm saying is it's allowing for the possibility that they've made a mistake.
Well, that I'll agree with you on.
It's essentially saying, well, and in some situations, though, I mean, courts will expressly say, you know, if we had to decide this de novo, we would review it differently. I've seen that happen.
But that doesn't happen in all cases.
Correct, exactly.
Well, counsel, this is Justice Kirby. I'm going to push back explicitly on that. Abuse of discretion means that there are a range of reasonable outcomes, and the trial court's decision fell within that range. It may mean that if we were reviewing it de novo, we might reach a different decision. It does not mean that the trial court's decision was wrong, but we're letting it go. Explicitly, it does not mean that. And the Barker versus Wingo case indicated that this is a very mushy, indistinct area with a balancing of factors. Why would that kind of decision not be left in the discretion of the trial judge, where he is weighing and balancing a number of factors?
Well, what the Barker versus Wingo court ultimately said was they said that essentially they weren't going to set a national standard on all the different aspects of speedy trial review. But they specifically said that they were encouraging other jurisdictions to do so. And we're certainly not forbidding them from doing so. And for example, they listed, seemingly approvingly, they listed one example where a circuit had said that a delay of 9 months for a trial involving eyewitness testimony, that was just per se too long.
Well, that is an example of a situation in which a state is permitted to apply a more stringent standard than the Supreme Court says that the Constitution requires. That's not what we're dealing with here. So why is that if the trial court is entrusted with balancing a number of different factors, that usually is the kind of decision where you have a range of possible outcomes that could be correct. Why do we not entrust that to the trial court?
Well, I mean, if Your Honor were to compare this type of claim, for example, to a Fourth Amendment claim, virtually everything involving a motion to suppress over the Fourth Amendment gets reviewed or gets viewed under the totality of the circumstances. So whereas here you've got 4 different factors for a speedy trial claim, under the Fourth Amendment, in essence, you've got an infinite number of factors. At least you've usually got more than 4.
Okay.
And yet the U.S. Supreme Court, as well as this court, have both expressly said that those types of claims are reviewed de novo.
Okay.
Mr. Justice, this is Justice Page. Let's look at the facts of this particular case. You had Judge Johnson with a trial that was ready to go besides this one, where it was 3 years old. You had a child victim, and it was a younger victim. You had someone who really wanted to get that case over with, and he looked at it and said, well, I'll put this case off for 2.5 months. Shouldn't any reviewing court look at that and say that was reasonable, that was a discretionary decision? Again,
If this court were if I had appealed and just said that the trial court abused its discretion in granting a continuance, then yes, I think that the standard is abuse of discretion. But we're not looking at just 1 2.5 month event, although I would say that the court was wrong in granting that continuance. But we're not just looking at that. We're looking at, why when I set the trial in May, why do they set it out 6 months until November? And then when they set it out, and that's after he's already been in jail for 4 months. And then why, when they set it for trial in November, why do they set it for the same day as another trial that's been waiting for 3 years? And so,
with all due respect, that's done every day in every trial courtroom in the state of Tennessee. You don't have just one case on a docket. You have 3 or 4. And as we know how the system works, some of them settle, some plead on the criminal side, and you end up hoping to try a case every day. That's just the way the system works. Sometimes you end up without a case for that day, and sometimes you have 2.
Well, this court has previously said in, I believe it's State versus Wood, that overcrowded trial dockets, like I would submit Your Honor is describing, that weighs at least somewhat against the state in terms of the reason for the delay.
Well, is that, counsel, is that the kind of hindsight that we are required to apply under Barker versus Wingo, where we go back and we look at the trial court's fundamental system of docketing cases, or do we look at the situation that was presented with the trial court that day and factor that into the factors that are to be balanced?
I think both Barker and Doggett versus United States both say that we're supposed to look at the overall docketing situation, and that type of, just over excessive number of prosecutions compared to the number of judges, courtrooms, prosecutors, et cetera, that does weigh against the state, at least somewhat. It's not supposed to weigh as heavily as, well, the state, intentionally delays because they're hoping a defense witness dies or something, but it does weigh against the state.
Mr. Justice, I have a question. I'm somewhat sympathetic to a defendant who has a bond, an exorbitant bond set. I think it was over $1 million, correct, in this case? And
officially, I think it was 1 million. There was a general sessions order that orally purported to lower it to 500,000, but I don't think that's in the records. So yeah,
whether it was 500,000 or $1 million, he wasn't going to make his bond.
Right.
No chance. And he's in jail for around 13 months. But has there been any Tennessee case holding that a 13-month delay is a violation of speedy trial, the right to speedy trial?
I'm not aware of one, Your Honor, and that's one issue that I brought up in especially in my reply brief, is that I feel like this court has gotten it wrong on this issue of even granting the state 12 months to start with. There does have to be some type of delay that's significant enough to where it's considered presumptively prejudicial. But again, in Barker versus Wingo, in a couple different places, the Supreme Court suggested that 9 months could be unreasonable. They expressly say that for some cases, 9 months is unreasonable. They say,
and that was in 1972. Am I right? Barker versus Wingo was 19. The situation has escalated greatly since 1972. I was not even out of high school.
right. Well,
Yeah, but I'm not sure, over time, does that lessen our right to a speedy trial?
I don't think it does, because I believe that the Constitution is timeless. And I mean, if anything, I would prefer to be able to cite Your Honors to some 200 or 300-year-old case where the founding fathers addressed exactly what length of time they were contemplating as being reasonable. I've looked into that. Nothing really came forth, but so I would say, the older the better in general. And just because we've gotten sort of away from giving people speedy trials in recent years doesn't mean that we shouldn't get back to it.
Mr. Justice, this is Justice Bivens again. Does the resolution of the standard of review actually change the result in this case?
I mean, I argued it both to the Court of Criminal Appeals and to Your Honors both ways. So I'm going to say it shouldn't, but obviously de novo review is just known for being less deferential. And so in theory, it might help me. It might make a difference.
Justice, this is Justice Page. Of course, we have numerous cases that say questions of law are reviewed de novo. And you've argued this is a mixed question of law and fact, but there's always going to be some factual determination with respect to a motion to dismiss on a speedy trial. And when the trial judge looks at it, and if you look at the other states, how that part of it, the deference to the fact finding is reviewed, it's kind of all over the place. Some say abuse of discretion, some say you give deference, some say it has to be substantial evidence. What is your argument with respect to that part?
Honestly, Your Honor, I don't think I really made an argument with respect to that part on this. I just assumed that I think Tennessee, I don't think I made an argument in my brief on that. I do think Tennessee courts have just said that the trial court's factual findings are presumed correct unless the evidence preponderates otherwise. But in this case, I didn't focus on that because there aren't really any factual disputes that I see. The trial judge factually found that we had been demanding a speedy trial basically from the very beginning, that he was in jail. So I didn't see any factual disputes to dispute.
In terms of prejudice, which I guess in my view is one of the most important factors, and typically what we see there is, this witness died because of the delay, or I could not locate this witness because of the delay. Was there any indication here that this defendant could not mount a defense because of the delay in time? Or another, his ability to defend the case was impaired because of the passage of time?
There wasn't any specific evidence of that, no, Your Honor. There's always a possibility, and I think the Supreme Court has noted this, that there's always that point is often hard to show. And that's sort of why they even get into this term of delay being presumptively prejudicial. But no, there wasn't specific evidence of that.
I mean, he did have all of his everybody at the trailer park who saw this happen that he knew about. They were there, in other words, right?
There was one other one that did go missing. So not exactly. There was one other, but
it was didn't affect.
We did have several at least.
Right. Okay.
But I mean, ultimately, I just submit that Mr. Moon was denied a speedy trial because he kept asking. He asked for a speedy trial again, almost from the beginning. He kept asking for one. The state wouldn't give him one. The case takes over a year for what I submit the US Supreme Court would call a fairly simple case involving one eyewitness who's a cop. And that whole time he's in jail, he's under maximum security where he can only get out of his cell for a couple hours a day until, I don't know, a few weeks before the motion for new trial or the motion to dismiss hearing. He testifies he's depressed, thinking about the trial every day. Just under that circumstance, it seems like he's been denied a speedy trial. And ultimately, I submit the state's admissions of which factors at least somewhat favor Mr. Moon, combined with the trial court's findings of fact, pretty clearly established that 4 out of 4 factors weigh in Mr. Moon's favor, at least as the state says, minimally. The state admits that Mr. Moon demanded a speedy trial, although they don't put a lot of stock in that. They admit that he was prejudiced minimally. They admit that they say that there was delay. They admit that there was delay, but they say the trial was minimally delayed. So it was presumptively prejudicial delay, but not protracted. That's their language, protracted. The only factor that they outright contest is the reason for the delay. And I guess the reason why they contest this is, as the Supreme Court has said in Loud Hawk, reason for the delay is the flag all litigants seek to capture. But even though the state contests this and tries to say that, the defense caused the delay or whatever, the trial court's fact findings hurt them there. Because again, they show that that we had been asking for the trial since basically the beginning, or at the latest since May, and yet the trial is set in November, and then it gets bumped again. So I just submit that it's fairly clear that the state is at least, that all 4 factors, at least somewhat, at least minimally, weigh in the defendant's favor, and therefore the right was violated.
Mr. Justice, can you talk about why the 404B violation was not harmless error?
Yes, Your Honor. In this case, the 404 violation was harmful error, essentially because the state's case was weak. There were weak in the sense there were multiple defense witnesses who contradicted their main accuser. Their case was weak. The evidentiary error impacted multiple of those defense witnesses. And then third, the evidentiary error thwarted the defense rhythm. So first, their case was weak. This court has said in, I think, multiple cases, but especially in State versus Tolliver, that the harmfulness of the error is inversely proportional to the strength of the state's case. Here we had, including Mr. Moon himself, we had basically 5 eyewitnesses who said that either they didn't see him holding a gun, such as the cop who was nearby, Mr. Purdom, or they said outright that he just didn't have a gun, such as Mr. Moon himself and basically all the other acquaintances at the trailer park.
Well, this is Justice Page. Now, he did have a gun. He just said he didn't try to use it to shoot the officer, right?
Yes, you're right. I'm sorry, Your Honor. They said either they didn't see him holding a gun or that he didn't have it in his hands. Whereas the defense story was that it was in his pants, where it was supposed to be.
In your view, the only person who said that Mr. Moon tried to shoot the officer was the officer himself, correct?
Exactly. Yes, sir. And again, there was another cop who was there about, I think, 20, maybe 30 feet away, and who came close to saying the opposite. But I mean, he wouldn't come right out and say for sure Mr. Moon wasn't holding a gun. It was just, well, I was nearby, I didn't see it, that sort of thing. In contrast to those 5 eyewitnesses, you had the one accuser, the officer, who, from the defense's perspective, basically shot Mr. Moon in a panic and then lied to cover it up. And then the proof was undisputed that this officer had a motive, at least, whether he's telling the truth or lying. He had a motive to accuse Mr. Moon, which would be to save his career, protect himself from civil liability, and probably even protect himself from criminal liability for wrongly shooting a civilian. And then that same officer was even caught making on the video some sort of bizarre statements, such as saying that a 22 shell came out of Mr. Moon's gun. And this presumably would have been the time when he's claiming he was pulling the slide back on the gun. But Mr. Moon's gun wasn't missing any bullets, and it also wasn't a 22 caliber. So there wouldn't have been any 22 shell come out of it.
What was the, Mr. Justice, I didn't understand the bit about the slide being pulled back. Did that particular gun he actually had or was found at the scene have a slide? And if so, was it pulled back?
Well, it wasn't pulled back because there wasn't really a struggle, but I'm just saying the officer claimed that Mr. Moon pulled a gun out and that the officer then somehow was able to miraculously grab the gun without being shot, pulled it off to the side, pulled the slide back. And it was admitted that a lot of the time, normally when you pull the slide back on a gun, you would expect either a bullet to come out all the way to where it would be missing a bullet, or if you don't pull it back all the way, the bullet could just partially come out and then get jammed. And then the officer would be truly protected. He couldn't be shot. And neither one of those things happened.
This is Justice Page. The officer testified about he felt the gun. I think he used the words pulsating or tensing. Was there any expert testimony about that in this case? I'm no expert, but I don't know what that means.
There wasn't any expert testimony, and Your Honor, I don't understand what it means either. I tried arguing to the Court of Criminal Appeals that there was no legally sufficient proof to even find that Mr. Moon pulled the trigger, but they rejected that, and I didn't include that in my petition to Your Honors because I didn't think that that was the type of, broad enough issue that y'all were very interested in. But no, I don't believe that there was any meaningful evidence of any trigger pull either, even assuming that a gun was pulled on the officer. And so what you had, though, was with this evidence of drug dealing, which was used to inflame the jury, by bringing up allegations of meth dealing. Primarily, that evidence was used to inflame the jury against what could be called the best defense eyewitness, because Larry Chief Woods, was the only defense eyewitness who was positioned to Mr. Moon's right. And he testified he was only about 10 feet away, or at least a very short distance. And so he really had the best angle out of all five. And so, he's undercut by the evidence, but it also undercut these other people just because they're sort of associated with them. One of the other eyewitnesses, Donald Woods, was his son. And then J.J. Smith is, he's a kid, so I don't think anyone would suspect he's a meth dealer, but he's still associated with these other people. The evidence, the 404 evidence was brought up in three different witnesses throughout the trial. It was brought up before the defendant himself and Chief and Donald. So again, I'd say that the 404 evidence was harmful because it impacted multiple witnesses. And then third, the error did impact the defense rhythm and thwarted that rhythm. I would say, I'm asserting it to your honors, but you can also look in the transcript, and there are, transcript parts that are quoted in the brief where I made it clear even at the time that I'm having trouble corralling my witnesses. And I even asked to be able to, take a witness out of order, and that was denied. And so ultimately we had to call Mr. Moon second instead of, I would have preferred to call him probably last. And so that was harmful as well. And so for those reasons, I would just say that the rule, that the error was harmful. And just, I guess before my time is up, I would like to just jump back on this standard of review issue. Again, the jurisdictions are almost unanimous, or they're overwhelmingly in favor of some sort of de novo review as to the legal application of the proven facts on a speedy trial claim. All the federal circuits with criminal jurisdiction apply de novo review as a mixed question of law to at least some speedy trial claims. As the state has pointed out, there's a couple of them, the first and the second, that for some reason they're applied deference on constitutional speedy trial claims, whereas they apply de novo on statutory speedy trial claims. But I mean, as even the judges in those circuits seem to admit that doesn't make a lot of sense. The Second Circuit calls their abuse of discretion in that context. They say it's a term of art, and then they sort of go out of their way to explain that they're not really applying abuse of discretion. And so I just submit it's fairly overwhelming that de novo should be the right standard of review for that type of mixed question. And with that, I'll come back for rebuttal.
Thank you, Mr. Justice. Ms. Simpson, you may proceed.
Good morning, Your Honors. May it please the court, Samantha Simpson on behalf of the state of Tennessee. Your Honors, this court should adopt the abuse of discretion standard of review for speedy trial claims for 3 reasons. First, the speedy trial right is fundamentally different from other constitutional rights. Second, speedy trial claims are fact intensive. And third, the abuse of discretion standard of review preserves appellate oversight of the development of law in this field. In Barker versus Wingo, which Your Honors have mentioned several times already, the United States Supreme Court specifically rejected a bright line rule in speedy trial cases. And in doing so, the United States Supreme Court noted that speedy trial rights are very different from other constitutional rights. First, society itself has an interest in ensuring that a defendant has a speedy trial, as does the state, if delays can cause a missing state witness just as well. And the trial court has an interest in ensuring that the defendant has a speedy trial to prevent overloading of the trial court's dockets. The court also noted, however, that unlike many other constitutional rights, a defendant can actually benefit from the deprivation of a speedy trial right. And the court noted, most importantly, that the right to a speedy trial is a more vague concept than other procedural rights. And because of all these differences, the United States Supreme Court adopted an ad hoc balancing test, which this court also applies. And it noted that this ad hoc balancing test allows the trial court to exercise a judicial discretion based on the circumstances, including due consideration of any applicable formal procedural rule. And we see the United States Supreme Court's deference to the trial courts or district courts continued in Doggett versus United States, where the court stated that it reviews trial court determinations of the state's negligence with considerable deference. Thus, the United States Supreme Court has opened the path to allowing and showing that abuse of discretion is the right standard of review for speedy trial claims.
Counsel, this is Justice Kirby. How does that last point counsel in favor? It seems as though the state's negligence is more of a factual issue that would have to do with assessment of credibility and so forth, where we do defer to the trial court. But that's the factual underpinning for the speedy trial claim, not the legal determination of whether the defendant was deprived.
Correct, Your Honor. The reason for the delay would be a factual determination, but in Doggett, the court noted that because the evidence supported the trial court's factual finding and overall determinations, it would not disturb the trial court's determinations in that case. So again, the United States Supreme Court makes clear that trial courts, because of this vague, different constitutional right, trial courts should not be bound by per se rules, but should have the flexibility to balance all the interests at stake in a speedy trial claim: the interests of the defendant, the interests of the public, the interest of the state and the trial court itself. And here we see a perfect example of that balancing. As your honors have noted, the trial court here granted the state's motion to continue in November because there had been an older child rape case that was set for, I believe, the day after this case had been set. And in denying the defendant's motion to dismiss, the trial court noted that unlike the defendant's contention that this was a simple street crime, in all actuality, this case was complicated. And in
This case actually, as it turned out, was not that complicated, was it? There were, the state had four witnesses?
Yes, Your Honor.
And a very limited, or was there any expert testimony? Well, there was, the investigator testified, the officer, another officer, then a special agent. There was not, I mean, it was very basic. He said, as it turned out, it was a he said, they said situation, correct, at trial?
Yes, Your Honor. The main issues that the jury had to consider was weighing the testimony, but there were numerous witnesses, I believe 9 in total, that needed to testify. Additionally, this case was complicated because the defendant faced several felony charges. It wasn't just a simple misdemeanor case. This was a serious attempted first-degree murder case. So the trial court looked at all of those facts, the fact that there were multiple witnesses that needed to testify, the fact that the defendant was facing serious felony charges. And at that motion to dismiss hearing, defense counsel informed the trial court that he estimated the case would need 3 days to try. And considering all those facts, the trial court reasonably granted that motion to continue. And to continue on why abuse of discretion is the best standard of review for speedy trial claims, opposing counsel mentioned Fourth Amendment claims. And in his reply brief, he cites to Ornelas versus United States, where the Supreme Court did apply a de novo review to a trial court's determinations of whether or not probable cause and reasonable suspicion existed. But speedy trial claims are fundamentally different from Fourth Amendment claims. Fourth Amendment claims can largely be categorized similarly. For example, you have dog sniff cases, you have knock and talk cases, you have plain smell cases. Speedy trial claims cannot be easily categorized. Every defendant's prejudice is going to be very individualized. The length of delay is
Ms.
never—
Simpson, this is Justice Bivens. Let me interrupt you there. How is a Fourth Amendment search and seizure matter not a very specific case when you're considering the totality of the circumstances? It's all very fact specific.
It is, Your Honor. But
so why does that make speedy trial different than that setting?
Another difference that the Supreme Court noted, or its reasoning for applying the de novo review to Fourth Amendment claims in Ornelas, was that it wanted to create a body of law and essentially guidelines for police officers to rely on as they approached search and seizure incidences. We don't have that policy reason here. We don't have any law enforcement that is relying on speedy trial doctrine in order to conduct their jobs. So while, yes, Fourth Amendment claims are also fact intensive, there were additional reasons why de novo review was appropriate for Fourth Amendment claims, but is not appropriate here.
They're both based on the Constitution. They're both alleged constitutional violations, correct?
Yes, Your Honor.
That seems to be a pretty significant similarity. If this were a statutory violation, do you agree that perhaps we should consider an abuse of discretion standard there, or more likely to consider it with a statutory violation? You see,
yes,
there's a difference between the constitutional versus statutory violation. I guess that's a better way of saying it.
I do, Your Honor. However, Tennessee reviews other issues that involve constitutional rights under the abuse of discretion standard of review. For example, in claims of improper prosecutorial argument, which is related to the constitutional right to a fair trial, this court has applied the abuse of discretion standard of review to evaluate all of the different factors involved, including the alleged improper argument, how often it was stated, whether it was in the state's initial argument or rebuttal argument, and the prejudice to the defendant.
Well, at some point, everything gets down to a constitutional violation when you talk about right to a due process or a fair trial. But it seems here shouldn't we be more concerned about a constitutional violation and therefore give it a higher standard of review?
Your Honor, constitutional rights are undeniably very important, but with the abuse of discretion standard of review, it would still preserve appellate oversight to ensure that trial courts are correctly guaranteeing this right for defendants.
And would we be in the minority if we adopted a discretionary standard? Would that be a minority view among the states?
Yes, Your Honor. Georgia, Nebraska, Louisiana, and South Carolina have adopted the abuse of discretion standard of review and for speedy trial claims. And in doing so,
Ms. Simpson, this is Justice Page. Isn't it in the federal system overwhelmingly de novo review in this area?
yes, Your Honor. Only the First Circuit and Second Circuit have adopted abuse of discretion for constitutional speedy trial claims.
So it sounds like if we adopt abuse of discretion, we'll almost be an outlier court in Tennessee. Is that fair?
Yes, Your Honor, that is fair. But when Georgia adopted the abuse of discretion standard of review, the Georgia Supreme Court stated in Sweatman versus State, it looked at Barker versus Wingo and the Supreme Court's precedent and stated that the Barker test, quote, necessarily compels courts to approach speedy trial cases on an ad hoc basis, a task better suited to trial courts than appellate courts. And with the abuse of discretion standard of review, as Justice Kirby noted, the main difference between de novo and abuse of discretion is under de novo, if an appellate court disagrees with the outcome, and in doing so, reviewing both the factual findings and legal conclusions again, the appellate court can reverse. But under the abuse of discretion standard of review, a reviewing court should only reverse if the trial court applied an incorrect legal standard, reached a decision against logic or reasoning, or that caused an injustice to the party complaining.
Well,
So
counsel, this is Justice Kirby. How do you explain the fact that so many other states and that the federal jurisdictions don't agree with your reasoning? Why are they wrong?
Your Honor, they are wrong because it goes to the nature of how fact-intensive and unique each speedy trial claim is, and how the United States Supreme Court explicitly provided for an ad hoc balancing test. The trial court is in the best situation to look.
We would give appropriate deference to the trial court in its factual finding for the factual underpinnings for the speedy trial claim, right? I mean, we would defer to the trial court's assessment of credibility and so forth. That's a different matter than the legal decision of where you fall. Was there a violation or was there not?
Ms. Simpson, this is Justice Page. One thing I guess that I've always noted in these cases, many of the facts in one of these claims or the speedy trial violation claim are undisputed. You know when the offense date is, you know when the defendant was arrested, you know whether or not he or she was out on bond, you know when the first case was set, when it was continued, when it was actually tried. All that's usually undisputed. Doesn't that kind of go against your argument?
No, Your Honor, not necessarily. Here, the trial court, this court should also give deference to the trial court's legal conclusions because the trial court is in the best position to balance all of those factual findings that it also makes.
Well, aren't they in a better position under that line of reasoning on Fourth Amendment claims as well?
Again, Your Honor, the difference between Fourth Amendment claims and speedy trial claims is that in Fourth Amendment, courts also have a policy basis to ensure that there is a uniform rules or set of guidelines for law
But what
enforcement
policy
officers.
base, why does a policy basis make the trial court more appropriate to make that determination than the appellate court? I don't follow your logic on that one.
Your Honor, there is a policy reason in Fourth Amendment claims that
I
also
understand,
supports.
I understand that, but how does that make it better for the trial court judge when there's a lack of a policy? Why does it make it better for a trial court to make that determination? I'm not seeing the linkage there as far as the standard of review goes.
Well, without that reason also supporting, there's less of a need to ensure as much uniformity at the overall level of the doctrine. And speedy trial claims are so fact intensive and unique that even under a de novo review, there's going to be a wide variety of outcomes in the case law.
How is there not a policy reason? Speedy trial claim. And why is there not a need for the appellate courts to articulate, to apply things in a consistent way so the trial courts know what to expect and know when to push it to trial and when they have a little more leeway? So I'm not following your argument that there's somehow not policy reasons associated with the speedy trial claim.
Your Honor, there's not a specific policy reason to give guidelines for law enforcement officers. As Your Honor noted, there's always a policy, and part of the reason that we have the state Supreme Court is to ensure uniformity of case law across the whole state. That's the reason for Rule 11 for grants. So,
but don't we have an obligation in terms of policy to give guidance to trial courts and prosecutors on the need to resolve criminal cases in a fair time frame, given that a person is sitting in jail? That to me is an important policy, that we protect the rights of these individuals who are charged but not convicted, yet are already serving time. And in this case, there are no disputed facts, correct? And in terms of speedy trial?
Your Honor, to answer your first question, yes, it is a very important task of this court to ensure that defendants receive a speedy trial across the whole state. But the abuse of discretion standard of review would still accomplish that goal. If a trial court committed an error of law or caused an unjust result, then a reviewing court could reverse the trial court's decision, and if it found a speedy trial violation, could then dismiss the case. So
let me give you an opportunity for a do-over, Ms. Simpson. In answer to Justice Bivens' question, why again are speedy trial claims? Why would they fall in a different category than Fourth Amendment?
Partly because, again, we don't have the in speedy trial claims, we don't have quite the same policy needs as we do in Fourth Amendment.
Okay.
And it's a very different constitutional right that affects the trial court, the public, the defendant, and the state. And Justice Lee, I believe you were also asking about whether the facts were undisputed regarding the speedy trial claims. And for the most part, yes, as far as everyone agrees about the length of the delay. And as I believe you mentioned, Justice Lee, whether or not there was no impairment of the defense at the time of trial. So yes, there are undisputed facts.
And I wonder, my concern here is that, are we normalizing a delay in excess of 1 year by agreeing that, or would we be normalizing a delay beyond a year and agreeing with you that there was no speedy trial violation? A year is a long time to sit in jail waiting trial when you've asked for a speedy trial. Are we just going to say that's okay no matter what?
Not necessarily, Your Honor.
So what sets this case apart from a case that, say, any other one-year case? What would make this case, what would make the facts in this case a violation of the right to speedy trial under this time limit here, or this amount of delay? What would need to happen for this defendant to prevail on this claim given a 13-month delay?
First, the defendant would have needed to show specific, stronger evidence of prejudice.
So that he had a witness, the witness died, or he had a witness and the witness is now in prison or disappeared, whatever, something like that?
Yes, Your Honor. As you noted, prejudice, this court is clear that prejudice is the most important factor. And the impairment of the defendant's case or strategy is the most important consideration. And here, as defense counsel conceded, there is no allegation that his defense was impaired. And so the most important factor does not weigh in the defendant's favor because he has only alleged minimal prejudice, that he felt depressed, but he didn't back that up with any testimony that he had received mental health treatment, that
but can't we take judicial notice that if you're sitting in jail for over a year awaiting some serious charges to be resolved, you're going to be depressed? Do you need mental health testimony for that?
Well, Your Honor,
I'd be depressed if I were sitting there with $1 million bond over my head awaiting trial. I mean, wouldn't anybody?
That very well could be true, Your Honor. But in Barker versus Wingo, the United States Supreme Court noted that the right to a speedy trial is aimed at minimizing a defendant's prejudice and defendant's pretrial anxiety, not necessarily eliminating it. Complete elimination would be hard for anyone to. It is understandable that any defendant might experience some pretrial anxiety and depression.
Ms. Simpson, could you, I'm sorry.
No, go ahead, I'm finished, go ahead.
That's okay. I was just going to say, could you address the issue of harmless error 404B for us? I think we need a little bit of convincing here that this is harmless error.
Yes, Your Honor. Here, the state's questioning of Mr. Larry Woods about his pending drug charges was harmless error for several reasons. First, the state did not introduce any affirmative evidence of Mr. Woods's alleged drug dealing. The state.
But does that almost make it worse? The district attorney general lobbed this question out. You deal in drugs, and then the whole thing came to a stop. He didn't have proof right there. He just threw out the question.
Your Honor, the state had in its possession the indictments from Mr. Woods had been indicted for. Those were marked for identification during the jury out hearing and were not shown to the state. Additionally, before the jury, when the jury returned, Mr. Woods either pleaded the fifth or denied any misconduct. So,
let me ask you about that. This is my concern, is the DA asked a question that he shouldn't have asked. I think we're all in agreement with that. That should not have been asked, and it should not have been allowed in. Yet the DA didn't let it go at that. He brought it up over a dozen times during Chief Woods' cross-examination. He didn't just say, if you've been indicted for selling meth, I take the fifth, end of story. I counted like 14 different ways he questioned him about that. And then he moved on and asked another Mr. Woods, Donald Woods, I think, about the meth selling. And then he asked, of course, I guess the defendant about it, right? But it wasn't just a one-time deal. He saturated this jury with comments about this meth selling. And this Chief Woods had never been convicted of this. He was merely charged. And he's presumed innocent until proven guilty. So these were mere allegations at what point does a district attorney general cross the line in terms of bringing up something that is inadmissible?
Well, Your Honor, the trial court admitted the state's questioning. So the state likely continued because the trial court did not overrule or exclude that evidence at that point.
And that compounded the error, did.
Yeah.
Okay, I'm sorry, go ahead.
This is Justice Page. Let me interrupt you there. Do you concede that the trial court did not follow the requirements of 404B and the Channing Christian Act such that the CCA was correct in reviewing this de novo?
Your Honor, the state does concede that there was not clear and convincing evidence of Mr. Woods's prior bad acts.
Well, of course, he had his hearing piecemeal, and he made part of his ruling after the defendant had already testified, correct?
That is correct, Your Honor.
Yeah. Okay.
Oh, go ahead.
Well, let me ask you this way. I mean, the defendant says that the CCA was an error here because they actually did this backwards. And in looking, of course, harmless error, we always look at the strength of the state's case, and you'd have a much better case here. 4 other eyewitnesses said, yes, this defendant pulled a gun and tried to shoot the officer. But all you have is the officer's testimony. And yes, I guess we can say, well, the jury believed him, but as Justice Lee couched this, he said, they said. I mean, this harmless error analysis here that the CCA did, I guess, could be characterized as weak. How do you respond to that?
Your Honor, first, the state's proof was strong. Corporal Wilder gave detailed, credible testimony about his experience of the altercation between himself and Mr. Moon.
Was there any witness to corroborate Officer Wilder's the key testimony of whether this defendant pulled the gun? Was there any witness who corroborated that aspect?
Your Honor, firstly, the defendant himself admitted he had a gun, but no.
That he pulled the gun. That he pulled the gun.
Gotcha. No other witness saw that Mr. Moon pulled a gun. However, none of the other witnesses had a clear view.
What if the defendant had 10 witnesses and we had 1 taken out? I mean, the cumulative effect of a lot of witnesses saying, I was close by, I didn't see, because they're testifying about a negative. So how is that not crucial when you have one particular witness whose credibility is undercut in an inappropriate way?
Your Honor, all of the defense witnesses had issues with their testimony, not just Mr. Larry Woods. Defense counsel referred to Officer Purdom, but he also noted that Officer Purdom was quite a distance away. And other witnesses were either, again, quite a distance away or at a poor angle. And so while Mr. Larry Woods was the closest witness, he also admitted that his vision was poor. He had to pull out his glasses to read his statement at trial. And in his statement,
I get it, but I mean, doesn't the state has the burden of showing that this was harmless error, correct?
No, Your Honor, it's the defendant's burden
of showing that
the error was harmful.
That the error was harmful to his
Yes,
case?
Your Honor.
Okay.
But that's even assuming for a minute, Ms. Simpson, that the officer is credible. Isn't it still really difficult to claim that this is a strong case? Maybe certainly a case that the jury could possibly believe and find in favor of that based on finding him credible. But how is that a strong case when there's no other evidence other than his testimony? There's no evidence of another witness, another officer. There's no evidence of gun firing, anything, no, other than his own direct testimony.
Correct, Your Honor. One of the court noted, there's no scientific or expert testimony besides the TBI expert. But as far as the strength of the evidence, Corporal Wilder's testimony was the best evidence that and all that was needed, because he was there and had the best view of what was going on, because he was experiencing it.
All that was needed for a conviction, but that's a different question than whether it's a strong case or not.
Yes, Your Honor, but it's also strong because all of the eyewitnesses that the defendant called had issues with their testimony. They were either.
What about the officer? Did he not have some issues? He shot a man 5 times. And certainly might have been in some facing civil liability or perhaps criminal liability. So didn't the officer have some reason to remember very clearly that a gun was pointed at him? In other words, he had some credibility issues as well, or some reason to testify the way he did. Let me put it that way. And that was what the defense showed at trial.
Chief Justice Page, I see my time has expired. I have a brief moment to
You may respond
answer.
to the question. Yes, go ahead.
May I also conclude?
Yes, go ahead.
Thank
Quickly.
you, Your Honor. Justice Lee, any evidence of the officer's alleged motive to lie is not in the record. There's no evidence of that. So as far as credibility, the officer described in detail his experience of and his firmly held belief that his life was threatened and he was about to die. In conclusion, Your Honors, this court should adopt the abuse of discretion standard of review because it is the best standard of review to address the United States Supreme Court's ad hoc balancing test while preserving appellate oversight of the development of the speedy trial doctrine. And this court should affirm the defendant's convictions. Thank you.
Okay. Mr. Justice?
Your Honors, regarding the any evidence and whether it's in the record of the officer's motive, on the first trial volume, the first transcript of the trial volume on pages 85 and 86, that's where the officer admitted his motive. And I believe he's even the one that brought up the possibility of criminal liability, whereas I was just asking him about civil liability. In terms of the speedy trial issue, the state has said that we don't have that same policy reason here to set guidelines on a constitutional right or to have a firm body of law. I would submit that the trial judges, in the exact same way as police officers do who are interacting with stopped motorists and such, the trial judges need guidance on the right to a speedy trial. I don't think that if the citizens of Tennessee were all lawyers and they truly understood how this works, I don't think many of them would be thrilled that to know that they can be arrested for some crime, even a relatively simple crime, whether they're guilty or innocent, and that they've then got to wait in jail for over a year, even after they've demanded from the very beginning the right to a speedy trial. They've still got to wait over a year before anyone will even consider whether they're really innocent, whether they have any chance to put on that type of proof. I just submit that the state wants to have the right to just keep people in jail for 1 year or more, pretty much no matter what, and have it matter either very little or not at all in the speedy trial analysis. I submit that that's mistaken. And this court, in even setting the 1 year presumptively prejudicial mark, they didn't say 1 year, they said close to 1 year or approaching 1 year, but even setting that 1 year mark in State versus Utley, I just submit that this court misread Doggett in setting that. Doggett wasn't saying the Supreme Court, the US Supreme Court is endorsing a 1 year presumptively prejudicial mark. Doggett was simply saying, we've looked around, all the jurisdictions agree that once you get to 1 year, you're clearly past the mark. In other words, some of them were less than 1 year, but all of them agree that once you're at 1 year, then that's presumptively prejudicial. Again, in Barker versus Wingo, they brought up the phrase 9 months twice and seemed to imply that in at least some cases that's too long. regarding, just whether this is how we've always done it and this is the way we always have to do it, I submit the state ultimately has multiple ways to grant the right to a speedy trial and to uphold the right to a speedy trial. The state, of course, can mean, the word state has multiple meanings. It could mean a trial prosecutor or an attorney general, or it could mean the state legislature as a whole, the governor, things like that. The state, when you look at it that way, they can do numerous things to uphold the right to a speedy trial. They can hire more prosecutors, they can build more courtrooms. On a broader level, they could criminalize fewer offenses, arrest fewer people, or for the people that they do arrest, they can make them lighter plea offers to where they don't have to try as many cases. The point is, they've got numerous different options, but it's not right under the Sixth Amendment to just say none of the above. We're not going to do any of those things, and we're just going to make you wait and just make you sit in jail, maximum security or otherwise. With regard to whether Mr. Moon was prejudiced, I submit that he was. Barker versus Wingo lists 3 different types of prejudice, and loss of trial witnesses is only one of the 3. Mr. Moon satisfied the other 2. With regard to prejudice in Klopfer versus North Carolina, the U.S. Supreme Court considered it prejudice just that someone was exposed to public scorn. So there was no loss of trial witnesses there. In Doggett versus United States, they emphasized that it's possible to have a speedy trial violation even without any prejudice at all. In that case, the guy wasn't even exposed to any public scorn because he was just indicted in secret and didn't even find out about it until years later. So the point is there are numerous different forms of prejudice. We showed prejudice here, and even when there is no prejudice, you can still have a violation. The state has said that the Supreme Court thinks that states should not be bound by per se rules, but in footnote 29 of Barker versus Wingo, the Supreme Court said, nothing we have said should be interpreted as disapproving a presumptive rule adopted by a court in the exercise of its supervisory powers, which establishes a fixed time period within which cases must normally be brought. And so in essence, we're a big country. In Barker versus Wingo, the Supreme Court was saying, this is a big country, principles of federalism, all that. We're not going to set all the nitty gritty rules, although we're going to set some of them, but we're going to leave it to the Tennessee Supreme Court to set some of these presumptive rules should they feel it wise to do so. And that's what I'm asking here. I'm asking to clarify that, among other things, that this 1-year thing is not just carte blanche for the state to just put some away and make them wait. Unless there are any further questions, I would ask for reversal and dismissal of the indictment.
All right, thank you very much, counsel, for your good arguments. And those of you who watched us on the live stream this morning, that concludes our first case. We will be reconvening at 10:30 Central Time for our second case this morning.
This honorable court is now in recess until 10:30 a.m.